Haven't met. I'm the new dean here at the law school. It's my pleasure to welcome everyone to the Student Scholar series. I will tell you one of the things that I asked about when I was interviewing for the job is, was there something at the law school where we recognized student scholarship? And I was very pleased to learn that this event occurred on an annual basis. So it was one thing that I knew I didn't have to start. It was already underway. And as I think all of you know, it got underway about 5 years ago to recognize what's very important, and that is scholarship by the students. Obviously, faculty is well known for scholarship. That's a core thing that faculty are expected to do and do here very well. But it really starts with the students in terms of scholarship. One of the best ways that the faculty can grow in their own scholarship and pursuits is to encourage that among the students, and I'm delighted that we have this particular event here today. So without further ado, I wanted to turn it over to our real master of ceremonies, Professor Harmon.
Thank you all for coming again to the first of our presentations in this year's 2012-2013 Student Scholar Series. Before I introduce Roger Abbott, who is our student scholar that will speak today, I'll introduce the respondent to his presentation, John Drakowski. John is a 2008 graduate of the Columbus School of Law. He was a former student. You will notice that he is remarkable. I had a lot to do with that. And he's an attorney with Butt Savage and Associates and practices in the areas of labor and employment law, election and campaign finance law, and provides legislative and regulatory counsel to unions, elected officials, and nonprofit organizations. He specializes in the legal and practical aspects of public campaigns, including the use of media such as radio and print advertising, websites, social media, direct mail, email, flyers, leaflets, and policy briefs. We thank him for joining us here today. And now let me introduce our presenter, Roger Abbott. Roger matriculated at Oxford University in 2003 and was awarded a BA with honors in 2006 in modern history and politics and an MPhil in 2008 in modern European history. After finishing his MPhil, he returned home to the U.S. and worked at the Competitive Enterprise Institute from August 2009 until 2010. A former intern with Judges Victor Walsky and Lauren Smith, both at the U.S. Court of Federal Claims, Roger is the past president of the Federalist Society and a staff member on the CUA Law Review. This spring, the review will publish his comment, "Is Economic Protectionism a Legitimate Governmental Interest under Rational Basis Review?" Roger will begin a 2-year clerkship with Judge Lawrence J. Block on the Court of Federal Claims this coming fall. Roger's interest in his topic today was piqued by the publicity that immediately arose after the 2010 decision in Citizens United versus FEC and the public policy issues that were implicated. Several classes with Professor Sarah Duggan, who nominated his work for the series this year, allowed him to gain further knowledge as to the constitutional aspects of the case. I'll now turn the floor over to the first of this year's student scholars, Roger Abbott. The title of his presentation, Enhancing Disclosure and Corporate Responsibility Following Citizens United. Roger.
Thank you very much, Dean. Thank you very much, Professor Harmon, for organizing this event, Professor Duggan for her support throughout the writing process, Mr. Drakowski for coming here and commenting, and all of you for attending. The title, as you can see, is Enhancing Disclosure and Increasing Corporate Responsibility Following Citizens United. And I'd like to do several things in this presentation. I'd like to introduce the legal landscape following Citizens United, especially regarding disclosure, discuss the utility of disclosure, and finally introduce a proposal which would be to require nonprofits to create electoral activity accounts in order to make electioneering communications. Now, Citizens United was very controversial, as all of you know, and many critics of the decision predicted that it would it would result in the voices of ordinary Americans being drowned out by large corporate contributions and expenditures. And in fact, there has been a continuing rise in expenditure with $6 billion in total spending in the 2012 election. Although you have to understand the context that the spending has continued to increase in recent years, Americans spend more on potato chips and video games than on elections. And in contrast to European countries which don't have federalist systems, we have, in 2012, for instance, Americans elected not just a president, but 435 congressmen, 33 senators, and a lot of state, local officials, judges, so on and so forth. The development I find more troubling has been the growth in anonymous contributions, which I refer to as, which many critics have referred to, dark money, because they're veiled, because the identity of the donors is veiled, and the way they do this is by donating money to nonprofits, which are then able to take advantage of a loophole in the law. And now there have been several different factors that have caused this emergence of dark money. And first of all, on the supply side, an FEC regulation, which has been in place for some time, which only requires donors to disclose contributions if they're specifically earmarked for electioneering communications. Makes it easier to evade the disclosure requirements of Section 201 of the Bipartisan Campaign Reform Act. And this has been in place for some time, but because Citizens United, before Citizens United, only MCA corporations had to contribute to PACs. They couldn't contribute directly. Only so-called MCFL corporations, which were basically ideologically driven nonprofit corporations, were allowed to make these types of donations. Unions and for-profit corporations couldn't. But after Citizens United, that essentially opened the door for these other type of organizations to make anonymous contributions into to skirt federal disclosure requirements. And then on the demand side, federal requirements which limit direct contributions to candidates actually require, as a result, corporations to give to independent and outside groups. And that also undermines the accountability of the process because candidates don't have to take responsibility for their message. Very quickly, the Citizens United decision is most famous for striking down PACs and contribution limits. However, in Section 203, it importantly, for the purposes of this paper, it upheld the disclosure requirements in Section 201, which require persons to disclose expenditures of over $10,000 and the names and addresses of individuals or persons, rather natural or unnatural, who donate who donate over $1,000, who give over $1,000, and the language itself is slightly cloudy. It says every person who makes a disbursement for the direct cost of producing and airing electionary communications. And this begs the question of whether only direct contributions, which are specifically earmarked as the FEC regulations currently require, are subject to the disclosure requirement, or whether Section 201 can be read more broadly. And as a result, a difficult issue and a constitutional issue has arisen is how to deal with donations which are given for mixed purposes. So if a corporation or an individual gives money to a nonprofit without saying that it's specifically for electioneering communications, how do you regulate that money? Because the Supreme Court does allow Congress to regulate electioneering communications, but it's much more skeptical of of regulations that reach beyond that. And here, again, is the actual language of the FEC regulation, which essentially only requires contributions that are specifically earmarked for electioneering communications to be disclosed. And by electioneering, I realize I haven't actually mentioned, but by electioneering communications, I mean communications which are advocating the defeat or the victory of a particular candidate or on a particular issue in the case of a referendum. But it does not include general campaigning, such as getting out the vote or other types of messaging. Those aren't subsumed included in that definition. And here, as you say in Form 9, the FEC actually explicitly says that if the donations are not, in the instructions it says that if the donations aren't specifically earmarked for electioneering communications, that the FEC filers don't have to disclose those contributions. Now I'd like to discuss briefly the issue of corporate responsibility, which is one of the issues that we studied with Professor Duggan. And that has emerged it emerged in the 1930s with the debate between Merle and with Adolf Berle and Merrick Dodd. And essentially, the whole concept arose out of the notion that corporations are becoming increasingly powerful and difficult to regulate due to their size and ability to move beyond borders. And however, I'm talking more about corporate responsibility as opposed to corporate social responsibility. Corporate social responsibility is a very broad term that encompasses the interests of various stakeholders, including everything from workers to broader society, the environment, while corporate responsibility is generally used to discuss issues of corporate governance, such as accounting standards or transparency. And as I argue, transparency is a very important element of corporate responsibility for several reasons. First of all, it's necessary for voter information. Basically, voters don't have very limited time and are unable to assess the merits of all the advertisements they see, and therefore they rely on cognitive shortcuts, as Wilson says, to basically they draw associations between the donor and the message. And this is especially important in state and judicial elections where you don't necessarily have rapid response teams which can address advertisements or to disprove advertisements. And it also the Supreme Court has recognized that that Congress has a compelling interest to prevent corruption and the appearance of corruption. And again, here, thanks to the internet, it's easier if people know who's giving the money to be able to see if, say, a large donation is followed by a political benefit. And it's easier to identify quid pro quo, and however, transparency and disclosure is vital for that. And finally, candidate accountability. It's important for candidates to be able to take responsibility for their own messaging. And current law actually requires, because so much of the spending is done by independent groups, and who are not allowed to coordinate with candidates. You have an awkward circumstances in which candidates can say, well, like in the Republican primary, for instance, where Romney was saying, well, I didn't really mean to say that. That was just my PAC, whom I can't control. And you had that going on in the past election. And here is an example I use of problems that are of dark money in action, so to speak. And in this particular case, this was California Proposition 30, in which Governor Jerry Brown was trying to raise taxes. And the donors basically gave money first anonymous donors gave first $11 million in contributions to a group called Americans for Job Security, which in turn gave the money to censure to protect patient rights, which in turn funneled the money to Americans for responsible leadership, and which finally actually made the advertisement purchases. And because of essentially a form of money laundering, it's very difficult to see who's actually giving the money. And most of these groups have very anodyne names. So, for instance, Priorities USA was one of President Obama's groups, and which also has a very similar sort of innocent sound. They all have very innocent sounding titles. Now, there have been concerns over compelled disclosure, and to the extent that which disclosure of political contributions violates constitutional protections of the right to speak anonymously. And Justice Thomas, in particular, has been particularly concerned with this. He was the sole dissenting in Citizens United on this particular issue, and basically said that there had in recent years been many instances of voter harassment or intimidation, and this goes back to, for instance, the NAACP versus Alabama case, in which people who opposed it, in which people tried to intimidate the NAACP by forcing it to disclose the donors so that they could intimidate the donors and prevent them from contributing. And similar concerns have been brought up, and Justice Thomas also offered in an 8-1, which decision, Doe v. Reed, which was handed down several months after Citizens United, also in 2010, talked about the same issue again. However, as I argue in my paper, the right to speak anonymously is not absolute, and disclosure is still the least restrictive means of ensuring transparency. Also, a lot of the harassment is illegal and can be enforced by appropriate state laws, and further laws could be passed and enforced on that matter. And also, corporations in particular have large resources and tend to be able to deal with this pretty well. And although this isn't in the direct context of campaign finance, for instance, there was a brouhaha in 2012 when Dan Cathy, the CEO of Chick-fil-A, made disparaging remarks about in gay marriage, and this led to sort of various protests which were widely publicized. And then there were actually various, however, I guess conservative supporters of Dan Cathy had sort of counter-protests and eat-ins at Chick-fil-A. And so I think especially in the case of a corporation which has multiple offices or branches throughout the country, they're much better able to protect themselves. And in fact, here's another colorful quote from Justice Scalia, that requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed, and that he does not want to live in a society in which you have anonymous contributions, that this does not resemble the home of the brave. And I guess this, and Justice Scalia actually has taken almost an extreme view on pro-disclosure view. In one case, actually in the 90s, saying that there is not anonymous pamphleteering isn't even necessarily protected by the Constitution. And finally, I get to my proposal. And before talking about the proposal, I'd like to just, I guess, frame the debate that the court has recognized that Congress has a compelling interest to require disclosure of electioneering communications. However, at the same time, the court has been very strict about, has allowed that for electioneering communications, but has been strict about not allowing Congress to reach far beyond that. And in fact, in Citizens United, for instance, the court found that PACs that the requirement to spend money using PACs created a substantial burden, and therefore that creates a challenge of how do you actually deal with mixed contributions and with disclosure without putting too much of without burdening other types of speech. And my proposal, which is based loosely on a Colorado law, although I don't take it exactly, but is basically to require nonprofits to create electoral activity accounts and to only use those electoral activity accounts to fund electioneering communications. And this would solve the problem of mixed funding so it would basically require nonprofits to ask their donors if they want to spend money specifically on electioneering communications to make that intent known so that the money can go into a separate account, and otherwise money that needs to be spent, that is donated for other purposes, can go into the general account. And I argue that that if done as mainly an exercise, ideally in a bookmarking exercise, it should be less burdensome than PACs. There would be no need to have separate officers who manage that. It wouldn't have to be separate from the company, so to speak. And I think that would probably have a good chance of being upheld. And with that, I'd like to thank you all for coming, and I invite Mr. Durkowski to comment. Thank you.
Thank you, Roger. Also, thank you, Professors Duggan and Harmon, for inviting me to comment on Roger's paper. I thought Roger's paper was really exemplary. It was a great piece of work. I practice in this area, and as I was saying to Roger, I don't know if they'll ever practice in this area, but I find it an interesting kind of game to put together these types of organizations, PACs or nonprofit organizations that meet my clients' needs in various ways, and everybody has a different need, it seems. So I guess that keeps me in business. I also wanted to say that I was really pleased to hear that the university had started this program, and I think it's a great opportunity for students to create publishable works, or at least the seed of a publishable work before they leave law school. I think that was really important to me when I was in law school, and I think it's important to the life of the university and the life of the mind. So I really appreciate that. Roger, I think the first question I have is a comment and a question. I think, and from our respective biographies, you can tell that we kind of come at a lot of issues from different sides of the spectrum. But I think in one way we probably disagree on campaign finance, and that has to do with the ability to give unlimited amounts of money to political causes. I think we would disagree on that. But for the purposes of your paper, I think a lot of what you're saying we agree on, which is the need for disclosure. And I think it's kind of neat that we can kind of come together and talk agreement. However, disclosure still makes me a little bit nervous, and it makes me nervous in this way. I wonder whether or not people become desensitized to disclosure, and whether or not after so much has been disclosed, I mean, $300 million, I know that people spend more on dog food and french fries and potato chips than that, but $300 million to most people, I think, is kind of what I like to call funny money. People just don't even comprehend that amount of money. So I guess, after a while of hearing $300 million, the next election will be $400 million, the election after that $500 million, do people turn off to disclosure? And is there a way to deal with that problem? Is there a way to deal with people kind of desensitizing and tuning out the disclosure? That's my first question.
Thank you. I think that's an important issue, and certainly public cynicism is a problem. I think the difficulty is we have to recognize that the country has changed a lot. And for instance, in the 19th century, I recently was reading the autobiography by the grandson of President John Quincy Adams about his sort of experiences. And one of the interesting things is back in the mid-19th century, if you lived in Washington, you could knock on the door of the president, knock on the door of any senator, meet them at any bar. It was a much smaller country in which politics was much more immediate, and sure, there were machine politics, but it was quite different back then. I think now the country is so vast that people don't have the same expectation of direct political participation. People who want to participate in politics do it by joining a group. If they might join a Tea Party, they might join a union, they might join various other associations. And communication is also much more expensive just because it has to be done through the media markets, which are extremely expensive. So I don't think necessarily the money per se is the problem. I think the biggest problem is, again, with not knowing who's making the contributions, because then people sort of, as I mentioned earlier, people are unable to judge evaluate the merits of all the messages that they're bombarded with in the media, because they don't know who's donating the money, and I think that's a real problem. Also, lost my train of thought, but I think that's the biggest. The other problem is also that current laws require people to donate to independent groups, and as a result, you have groups, outside groups, essentially speaking for the candidate, but not really. People generally know what side they're on, but they're not necessarily, because they're prohibited from coordinating with candidates. The candidates don't have to take responsibility for the messages that they give, and the candidates essentially lose control of their own campaigns. And this leads to a real muddying of the waters. And I think that's a real problem right now, where a lot of the advertisements are spent by outside groups precisely because corporations, for instance, are not allowed to contribute directly to the candidates.
Yeah, I mean, and do you think? I guess I am in agreement with the idea that candidates lose control of their campaigns. But do you think that further disclosure would encourage people to give directly to candidates? I mean, I guess how would further disclosure affect the problem of candidates losing control of their campaigns or these outside?
I think, as I addressed here, there's both a supply problem and a demand problem. And on the supply side, you have the FEC loophole, which essentially allows corporations to give money to cloud their contributions by funneling money through nonprofits. And then on the demand side, I think you have federal laws that prevent candidates, corporations from giving directly to candidates. And I think if you loosen some of those limits, people would actually be willing to give money directly to the candidates, because recent history shows that electioneering spending by independent groups isn't all that effective. You saw in 2004, Soros spent millions of dollars. In 2012, American Crossroads and other conservative groups spent hundreds of millions of dollars, and they weren't particularly effective. So I think money is spent much more effectively if the candidate has an opportunity to have a coherent message. So I think that would create a strong incentive to contribute to the candidate instead of to outside groups if they were allowed to.
The other question I wanted to ask, and then probably should let other people ask some questions, was about, and you said it in your presentation, was the term money laundering. I know, and because I practice in this area, there's a lot of states that prohibit the, and again, it's not totally fair to give this to you, but I'll give you the example, and then maybe if you can just respond to it, that'd be great. There's a lot of states that prohibit the contributing or donating of funds to one person for the purpose of that person turning around to contribute it to a campaign, to kind of hide the identity of the first contributor or donor. And again, contribution in election law is a term of art, so we should probably say donate to one person so they can donate to another person in the election law context. And like the state of Virginia, I know makes it a misdemeanor to do that. The state of Maryland has a prohibition on that as well, but I can't remember exactly what the penalty is for violating that prohibition. But I'm wondering, do you think that money laundering somehow has a role to play in all of this? Do you think that there's any room for kind of criminal enforcement of these things, or even on a federal level, which nobody really has been willing to go after lately?
I think certainly there's a potential there. I think you have to be careful. There are certain line drawing problems which would have to be dealt with. For instance, if a corporation if one group gives money to another group, it could be because they're trying to launder money, or it could be because that group is particularly good at advocacy, and the donating group is much better at, say, at some other form of at getting out the vote. So I think I think the challenge is to, again, constitutionally, is that the court allows gives Congress a much freer hands in requiring disclosure from electioneering communications than it does from to other types of so-called pure political speech, which Congress can't regulate as much. So I think you have to deal with those line drawing problems there.
Do you have any questions from the floor for Roger and John?
I had a quick question. It's a little bit outside the scope of what you're talking about, but has there been any discussion of, for instance, large American publicly traded corporations that have a large foreign shareholder percentage, whether we're seeing influence of foreign money in American election campaigns?
Not that I'm aware of. There are essentially Citizens United did not actually allow foreign contributions, and that hasn't been as much of a problem as far as I'm aware. But perhaps you could speak.
I know that there are prohibitions in federal law on foreign entities giving to any campaign, actually, whether it's on the federal level or the state level. Or
if the American corporation is giving the money, but the American corporation largely has foreign shareholders, are we seeing therefore that sort of indirect influence of foreign money?
My answer to that would be, I think so. It hasn't been brought up at the courts yet. And actually, one of the points Roger made in his paper, I think, was also about this disclosure stuff goes to shareholders' rights to know what the corporation is doing. And it's kind of the converse of what you're saying, but I think that shareholder problem is a big issue that, and in my opinion, in Citizens United, the court kind of glossed over and didn't really analyze in a way that I found very compelling at all.
I mean, it's difficult in an increasingly globalized world. It's difficult to deal with that. For instance, the New York Times is essentially owned by Carlos Slim, who's sort of a wealthy Mexican billionaire. So to what extent does that raise issues? I don't know, but I think that's just a thorny issue to deal with. Yes, Professor Rieger?
Well, I mean, let me sort of jump out of the regulatory text here and just ask you this. I think Mr. Romney reiterated and educated us that corporations are people too, my friends. So, but they're not citizens; they're people. So, what's the logic if you're not limiting corporations? What's the logic of limiting foreign people who are in America? I can see perhaps limiting someone in Zurich. But if it's a foreign individual in America, who I believe has problems contributing under the federal laws at least, or if it's a corporation that is foreign but has a U.S. office, what would be the logic of saying that once you say that any corporation can contribute, what's the logic of saying, well, but not domestic offices of foreign corporations?
I think, again, it goes back to the anti-corruption interest, which was first articulated, I suppose, in Buckley, that Congress has a compelling interest in preventing corrupting influences, and therefore, in that sense, despite what the court said in Citizens United about not being able to discriminate on the basis of the identity of the speaker, I think in reality, and there they were talking about a distinction between natural persons and corporations. I think Congress has and probably will, I'm sure, continue, and I think it's a good thing to treat foreign donors differently just because of the potential corrupting effects. Again, there's difficult enforcement issues, and I'm not sure exactly how those will be dealt with. But
I mean, from my point of view, I think you're spot on with asking the question, and I think it's a question that under Citizens United, eventually the court's going to have to deal with. They've opened the door to those kinds of questions. Just yesterday, I was telling Roger they accepted a case in McCutcheon, which is a challenge by an individual and the Republican National Committee to an individual over 2 years has aggregate limits placed on them as to how much they can contribute to candidates and party committees. And the court just accepted a case on cert from the District of Columbia Court of Appeals regarding those aggregate limits. And like that case, I think the foreign entity question is going to have to come up at some point because the Citizens United decision is at least at an initial reading is quite expansive, and they're going to have to do, if they want to uphold those limitations, they're going to have to do certain legal gymnastics, I think, to do that. I'm not quite sure how they get there.
yeah, I mean, Citizens United doesn't expressly prohibit contribution limits. It sort of deals more with discriminating on the basis of the identity of speaker and the PAC requirements. So that's, I guess, an issue that's the whole issue of political contribution limits has been left open.
Do you have a view on the contribution limits? Because it seems like where we are now is that indirectly people like American Crossroads can raise a fortune, but directly if you want to contribute to a candidate, you're strictly limited. Do you have a view on where that ought to come out?
I think it's problematic to have, especially the limits on contributions to candidates, because again, I think that causes a lot of the problems that, in terms of loss of accountability, and that people can have to essentially give to independent groups and can't give to candidates. I mean, ideally, and I'm not sure to what extent this is practical. I think the ideal solution would be to have some sort of a Madisonian way of having internal checks, because I think, unfortunately, money in politics is, to a certain degree, is difficult to stop. And it seems like as soon as you close one tap, another one opens up. And so, to a certain extent, I think it's a better way of dealing with it is to making sure that everything is above board and to regulating it that way. Professor?
Roger, if disclosure is improved, and I'm thinking about contributions made by large public corporations, and I'm thinking about a situation in which the shareholders object to, rather than the shareholders influencing the way the corporation spends its money, instead the shareholders object to it, because after all, the managers are making the decision on how to contribute money. What good does it do the shareholders to know where the money is going?
Yeah, I think unfortunately, it doesn't help the shareholders all that much. It's more, I guess, from the point of view of voters knowing where the money is coming from. I guess inevitably under the business judgment rule, there's very little scope for shareholders to, I guess, challenge most management decisions. And this has become an issue not only with corporations but also with unions as well. And in California, there was a battle over, for instance, whether unions can how unions use contributions for political activity. But I mean, it's sort of problematic. Ideally, I think Warren Buffett had this. I mean, once you would pick out, I guess, 10 different charities and allow stockholders to essentially vote which one they preferred. But he did that, of course, on his own accord, and it only lasted a few years before he pulled away from that. But
I would just add that, I mean, I think that there is some space for shareholder activism. I don't think everything is necessarily dictated by the business judgment rule. I mean, obviously that's the rule, but in cases especially big institutional investors, like think of like CalPERS, which is the California pension system, or then there's actually like a council of institutional investors. Those sorts of large investors that have billions of dollars, they can act on the information that a corporation is giving to a certain candidate or a certain cause, and oftentimes have successfully acted on that kind of information, really kind of ruffled feathers within corporations. So that would be it's kind of on the margins, as Roger was saying, but on those margins at least it's useful.
Anyone else?
Well, I'm going to thank Roger for impressive beginning to this year's program. We have a token of our esteem. Roger for helping us out today. And John, thank you so much. Thank you all for coming. Next month at this time, we will convene again for the second presentation by Alyssa Laxon, a third year, whose work is entitled Subjected to Torture, Chevron, the Limitations on Judicial Review of Final Executive Orders for International Extradition. So this is heady stuff, and we're aiming high here. So again, thank you all for coming today, especially to Roger, to John, Professor Duggan, Dean Attridge, all of you for attending. Thank you.